Federal Judge Arthur Brennan just ejected Trump's lead defense attorney from his courtroom. Not a warning, not a fine complete removal by U.S. Marshals after what witnesses are calling the most explosive courtroom confrontation in modern American legal history. This isn't some routine procedural dispute or minor contempt citation. This is a sitting federal judge publicly declaring that a former president's legal team has crossed a line so egregious that the attorney must be physically escorted from the building. When federal judges start calling marshals to remove counsel in the middle of pretrial proceedings, you know something catastrophic has just shattered the boundaries of normal legal practice. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what set off this unprecedented meltdown? According to multiple reporters inside the courtroom on January 17th, defense attorney Emil Bowe III refused a direct judicial order to answer whether his client would comply with document production deadlines. Not once, not twice, 7 consecutive times he deflected, prompting Judge Brennan to issue the warning that would set everything in motion. This isn't just another contentious hearing or standard legal sparring. Members of the legal community are openly stating this represents a fundamental breakdown in the relationship between the bench and the former president's defense team. And believe me, when a federal judge reaches this breaking point, you know something enormous has just detonated in that courtroom. Here's the full picture of what's been unfolding. Tensions in Judge Brennan's courtroom have been simmering for months, fueled by repeated discovery violations, missed deadlines, and what prosecutors described in court filings as a deliberate strategy of obstruction through litigation. The friction intensified dramatically following a December 4th hearing where the defense team filed emergency motions at 11:47 p.m., just 13 minutes before a midnight deadline containing what the judge later called materially misleading representations about document availability. But everything escalated on January 17th when Judge Brennan convened an emergency status conference after receiving a sealed memorandum from the prosecution alleging the defense had provided contradictory statements about the existence of certain communications. The memorandum, dated January 14th, reportedly documents at least 4 instances where defense representations to the court differed substantially from evidence obtained through independent subpoenas. This wasn't about aggressive advocacy or zealous representation within bounds. It was about whether the court could trust anything the defense team was telling it. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Brennan reviewed the discrepancies in his chambers that morning, sources say he recognized immediately that the pattern couldn't be explained by honest mistake or miscommunication. And let's be honest for a moment. Federal judges don't remove attorneys from their courtrooms over routine disputes. They don't call marshals for typical discovery disagreements. They reach this point only when they believe the integrity of the proceedings themselves is under direct assault. Here's what multiple sources inside the courtroom say happened next. On January 17th at approximately 10 to 23 a.m. Eastern, Judge Brennan entered the courtroom with what observers described as an unusually stern demeanor. The gallery included 37 journalists from major outlets, 12 sketch artists, and approximately 60 members of the public who had lined up since 4 a.m. for the limited seating. Sources told Reuters that the judge began by reading a prepared statement outlining 7 specific instances of alleged misrepresentation. His voice measured but unmistakably cold. Meanwhile, the defense team appeared visibly unsettled. Lead attorney Emil Bowe III reportedly shuffled papers while avoiding direct eye contact with the bench. By the 40-minute mark, Judge Brennan had transitioned from reading his statement to direct questioning, and that's when the confrontation truly began. The judge's first question was deceptively simple. "Mr. Bowe," the judge began, his tone carrying an edge that silenced every whisper in the gallery. "I am going to ask you directly, and I expect a direct answer. Will your client comply with the January 31st document production deadline as currently ordered?" Bowe paused. "Your Honor," he replied, "we have filed a motion for reconsideration that addresses the timeline concerns, and that is not an answer." Judge Brennan cut in sharply. Yes or no? Will you comply? The exchange that followed would become the defining moment of the hearing. Both attempted to redirect 6 more times, citing pending appeals, executive privilege claims, and procedural objections. Each time, Judge Brennan interrupted with the same demand. Yes or no? Will you comply with this court's order? Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. On the 7th refusal, Judge Brennan set down his pen with deliberate precision. Mr. Bove, he said, his voice now carrying throughout the silent courtroom, I have given you 7 opportunities to provide a direct answer to a direct question. Your continued evasion leaves me no choice but to conclude that you are either unable or unwilling to engage with this court in good faith. The word unwilling hung in the air. Reporters in the gallery later described the moment as physically tense, with several marshals near the rear doors shifting their weight in anticipation. Then came the statement that would dominate headlines across every major network. Under my authority, pursuant to Federal Rule of Criminal Procedure 44 and the inherent powers of this court, Judge Brennan continued, I am finding you in contempt and ordering your immediate removal from these proceedings. You are barred from appearing in this courtroom until further notice. The color reportedly drained from Bove's face. Your Honor, he stammered, I must object in the strongest possible. Your objection is noted for the record, Judge Brennan replied, already motioning to the marshals. You have 60 seconds to gather your materials. This hearing is in recess for 15 minutes. That's when it became clear this isn't just another legal skirmish. The ejection of a lead defense attorney in a case involving a former president represents something we haven't witnessed in the modern era of American jurisprudence. When a federal judge publicly declares that he cannot trust the representations of counsel, it signals a breakdown that goes far beyond any individual dispute. This isn't the first time tensions between judges and defense attorneys have erupted in high-profile cases. Think back to the Watergate prosecutions, when Judge John Sirrah became known as Maximum John for his aggressive handling of Nixon administration defendants. His willingness to push back against obstruction tactics eventually forced the revelations that brought down a presidency. The pattern is instructive. When judges perceive the defendants are using legal process itself as a weapon of delay and deception, they eventually reach limits. Then there was the Iran-Contra affair, where independent counsel Lawrence Walsh faced repeated judicial confrontations over document production and claims of national security privilege. The key difference there was that judges generally extended more deference to claims of executive authority. What we're witnessing now suggests that deference may have finally exhausted itself. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the first impeachment proceedings, where Trump's legal team employed many of these same delay tactics. Some observers noted at the time that the strategy seemed designed not to win on merits, but to run out various clocks. The pattern is clear. When legal teams believe they can outlast judicial patience, they push boundaries. When they miscalculate that patience, the consequences are severe. So, what allegedly triggered Judge Brennan's explosive reaction? According to legal experts who have reviewed the public filings, the breaking point involved a specific document that the defense claimed didn't exist, then was forced to acknowledge existed after subpoenas to third parties revealed otherwise. A former federal prosecutor who spoke to NBC News explained that this type of contradiction strikes at the heart of judicial proceedings because courts simply cannot function if they cannot rely on attorney representations. Here's the kicker. The document in question reportedly contains communications that directly contradict sworn statements in earlier filings. This wasn't a minor discrepancy or good faith disagreement about interpretation. According to sources familiar with the matter, the contradiction was so stark that several members of the prosecution team exchanged visible glances when the defense finally acknowledged the document's existence. Don't go anywhere. The most explosive part is coming next, and here's what should alarm everyone who cares about the rule of law. This isn't just about one attorney or one hearing. If defense teams can make false representations to courts, then correct them only when independent evidence forces acknowledgement, the entire adversarial system breaks down. Once that pattern is established as acceptable practice, there's no limiting principle. Every case becomes a game of what can we get away with saying until we're caught. This puts the remaining defense team in a nearly impossible position. On one side, they must continue representing their client zealously, which the legal profession demands. That means making every possible argument, raising every potential objection, pursuing every avenue that might benefit the defense. On the other side, they now operate under a judge who has publicly declared his fundamental distrust of their representations. Every filing they submit, every statement they make in court will be scrutinized through a lens of suspicion. They now have to rebuild credibility that may be impossible to restore. And here's the tricky part. There's no credible defense to what happened. Either the document genuinely didn't exist when they said it didn't, which would require believing that a major law firm conducted a search so incompetent that it missed communications subsequently found by subpoena, or the document did exist and they misrepresented its status to the court, which is exactly what Judge Brennan appears to believe happened. Legal and political analysts are calling this a potential watershed moment. Jonathan Turley, George Washington University law professor and frequent conservative legal commentator, told Fox News that the ejection represents an extraordinary measure that judges reserve for the most serious breaches of professional conduct. He noted that while attorneys have been held in contempt before, the physical removal of lead counsel in a case of this magnitude is virtually unprecedented. Do me a favor and slam that like button because it genuinely helps this video reach more people, even Alan Dershowitz, who has defended Trump in previous proceedings, and often appears sympathetic to aggressive defense tactics, acknowledged in a CNN interview that Judge Brennan's patience had clearly been tested beyond reasonable limits. He emphasized that judges have inherent authority to maintain courtroom order and that repeated evasion of direct questions puts that order at risk. A former assistant attorney general who served under both Republican and Democratic administrations told MSNBC that the ejection reveals something deeper about the defense strategy. When you're removed from a courtroom for refusing to answer whether you'll comply with an order, she explained, you've essentially admitted that the answer is no, but you're hoping to avoid saying it explicitly. So let's break down what this could mean. First, the immediate legal impact is severe. Trump's defense team must now reorganize without their lead attorney, at least in this courtroom, while already operating under accelerated deadlines they have repeatedly sought to extend. Replacing lead counsel mid-proceedings creates massive coordination problems and potentially opens doors for prosecution arguments that any further delays are self-inflicted. Second, this creates precedent that other judges will notice. Federal judges across the country are watching how Brennan handles this situation. If his actions are upheld on appeal or simply not challenged effectively, it signals to the broader judicial community that aggressive pushback against obstructive tactics will be supported. Multiple sources in the federal judiciary have indicated that many judges have been frustrated by similar behavior, but hesitant to take dramatic action. Finally, looking ahead, the political implications compound the legal problems. A recent Quinnipiac poll found that 67% of independents believe Trump should comply with court orders without qualification. The image of his attorney being physically removed by marshals reinforces narratives about disregard for legal process that have damaged his standing with crucial swing voters. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate fallout, this is really about fundamental constitutional principles. The relationship between courts and litigants, even the most powerful litigants, depends on mutual recognition of judicial authority. When attorneys refuse to answer direct questions from judges, they aren't just being evasive. They're challenging the basic premise that courts have the power to compel truthful responses. If that premise fails, the entire edifice of American justice becomes merely advisory. This scenario is causing sheer panic within Trump's broader legal orbit. Reports indicate that attorneys across his various cases held emergency conference calls within hours of the ejection. Some argued for doubling down, filing immediate appeals challenging Brennan's authority and attacking the ejection as judicial overreach. Others reportedly urged a complete change in approach, warning that continued confrontation risks alienating judges across multiple jurisdictions simultaneously. Meanwhile, Trump's most vocal supporters are absolutely furious at what they characterize as judicial persecution. Social media is flooded with claims that Brennan is a deep state operative, that the ejection proves the system is rigged, that no legitimate judge would ever take such action against a former president's attorney. To the base, this represents more evidence of the weaponization of justice they have long claimed exists. Things escalated further when Trump himself posted a series of statements calling Judge Brennan a radical left judge and a Biden puppet who has no respect for presidential immunity or attorney-client privilege. He claimed the ejection was orchestrated by the Department of Justice and vowed that this communist judge will be dealt with when we take back the White House. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more damaging. Trump's response essentially confirms the dynamic Judge Brennan described. Instead of addressing the underlying issue, whether his team will comply with legitimate court orders, the reaction was pure deflection and personal attack. When your defense to a contempt finding is attacking the judge's politics rather than explaining your conduct, you've conceded the substantive point. Legal experts immediately flagged how this response compounds the problem. Every statement calling the judge corrupt or politically motivated can be cited in future proceedings as evidence of disrespect for judicial authority. Several analysts noted that judges in other Trump cases will certainly take note of how their colleague is being characterized publicly. This goes far beyond a single courtroom confrontation. It's about whether any court can effectively exercise authority over this particular defendant. If Trump can characterize every adverse ruling as persecution, every judge who rules against him as corrupt, every order he dislikes as illegitimate, then the legal system has no mechanism for accountability. Once that precedent is set, the rule of law means nothing for anyone with sufficient public platform to delegitimize judges. If this blows your mind, hit that like button right now. Here's where things stand right now. A federal judge just ejected a former president's lead attorney for contempt, declaring from the bench that he cannot trust the defense team's representations. The remaining attorneys must now navigate proceedings under a cloud of judicial suspicion while their client publicly attacks the judge as a political operative. Meanwhile, legal observers across the country are watching to see whether this moment represents an inflection point or simply another skirmish in an ongoing war between Trump and the institutions meant to hold him accountable. This isn't just another news cycle that will fade away. This is the American legal system testing whether its authority has any meaning when confronted by a defendant who refuses to recognize it. What happens next could determine whether federal courts retain the power to compel compliance from anyone regardless of political stature. The evidence is out there. The objection has occurred. The contempt is on the record. Now, we wait to see if accountability still holds any weight in a courtroom where the defendant believes he is above the very process designed to judge him. Keep a close eye on this story. Judge Brennan has scheduled a hearing for January 24th to address how proceedings will continue with restructured defense counsel. Multiple legal teams are reportedly preparing emergency appeals challenging the ejection, and courtroom observers across the federal judiciary are watching closely to see whether one judge's decision to finally say enough becomes a model for others facing similar tactics. Before we go any further, smash that subscribe button so you never miss content like this. The stakes have never been higher. The confrontation has never been more direct. And the question of whether American courts can function when a defendant simply refuses to play by the rules has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.